Renata Vasquez placed her bid on a Tuesday morning in September, sitting at the kitchen table of her sister's apartment with a cup of coffee that had gone cold and a laptop that was 3 years old and made a sound when it processed things that suggested it was thinking very hard and not entirely confident about the outcome. The bid was $7. She typed the number into the online auction form with the same deliberate attention she brought to things that mattered and clicked submit, and the laptop made its thinking sound, and the confirmation appeared on the screen, and she picked up the cold coffee and drank it, because the coffee being cold was not the most significant thing happening at the table that morning. The property the $7 was bid on was a narrow strip of land in the Callaway district of the city, described in the county tax auction listing as a non-residential parcel of 0.4 acres with no structures, tax delinquent for a period of 11 years following the dissolution of the holding company that had owned it. The outstanding liability was $6.87. The county required bids to be submitted in whole dollar amounts. Renata had bid $7. She was 44 years old. She had been a land use attorney for 16 years before the firm she had worked at had restructured itself out of 3 senior associates, including her, in a process that had been described as strategic realignment, and that she had described to her sister Carmen as a convenient way of not paying 3 expensive salaries during a difficult year for the commercial real estate sector. That had been 14 months ago. She had not found another position because the market for land use attorneys had contracted in the same difficult year, and because the firms that were hiring younger associates at lower rates, and because 14 months of applications and interviews had produced the specific accumulated exhaustion of a person who had been qualified and experienced and consistently unsuccessful in ways that had nothing to do with the quality of the qualification or the experience. She was living in Carmen's spare room. She had $430 in her account. She had the laptop and her professional library of land use law texts and a 16-year working knowledge of property law, zoning regulations, environmental assessments, and the specific bureaucratic infrastructure of the city's development approval process that was the kind of knowledge that could not be acquired quickly or cheaply, and that she had been trying for 14 months to convert into employment without success. The 0.4 acres on Callaway she had not found by browsing. She had found it by doing what she had been doing for 6 weeks, which was reading every county tax auction listing with the focused attention of someone who had spent 16 years understanding what land was and what it was worth and why, and looking for the specific type of listing that most bidders would not look at carefully, because most bidders were not reading with her particular set of eyes. She had been reading with those eyes for 6 weeks before she found this listing. She had found it on a Monday. She had spent the rest of Monday and all of Tuesday morning before the bid reading everything she could find about the Callaway District parcel. The tax records going back 11 years, the zoning history, the surrounding development context, and most importantly, the planning documents that were publicly available through the city's development portal, and that she had accessed with the professional fluency of someone for whom planning document navigation was a practiced skill. She had found what she was looking for in the planning documents at 10:30 on Tuesday morning, 30 minutes before she submitted the bid. She had submitted the bid. Now she sat at the kitchen table with the cold coffee and the confirmation on the screen, and thought through what she had found one more time to make sure the thinking was sound. The Callaway District had been a working industrial area from the early 20th century through the 1980s, a zone of light manufacturing and warehousing that had declined in the specific way that urban industrial areas declined when the economics of urban manufacturing changed, and the buildings that had been built for function became the buildings that were converted for other purposes, or that sat in the specific limbo of areas that were between what they had been and what they were going to become. The Callaway District had been in that limbo for 30 years. It was coming out of the limbo now. Renata had been watching this happen for the 3 years before she lost her position, and the 14 months since, following the development activity in the district with the interest of someone who understood what urban land transitions looked like and what they meant for the parcels involved. A hotel had been built at the eastern end 4 years ago. A mixed-use development had been approved and was under construction at the northern boundary. 2 commercial buildings had been converted to residential use in the central section, and Callaway Capital Group, which was the largest commercial developer operating in the district, had been quietly assembling a land package for 3 years in preparation for a development they had not publicly announced, but that Renata had been able to read from the shape of their acquisitions and the planning pre-consultation documents they had filed, which were publicly available to anyone who knew where to look. The development was a $40 million mixed-use project that would cover approximately 3 acres of the district's central section. Callaway Capital had spent 3 years acquiring the parcels that made up the 3 acres, paying increasingly significant amounts for each one as the package came together, and as the sellers understood, as sellers inevitably did when a major developer was buying, that they were in a position to negotiate. The 0.4 acres that Renata had bid $7 for was in the middle of the 3-acre package. Not at the edge, not adjacent to the package. In the middle of it, a narrow strip that ran across the center of the proposed development footprint, like a spine, the specific position that made it not merely inconvenient to the development, but structurally essential to it. Without the 0.4 acres, the 3-acre package was 2 separate parcels that could not be developed as the unified project that Callaway Capital had designed and planned, and for which they had spent 3 years and significant money assembling the surrounding land. Callaway Capital had apparently not known about the tax delinquency on the central strip, or had known and had not moved on it, which would be a different kind of error with a different explanation, or had moved on it through a process that had not worked, which was the explanation Renata found most likely, given that the listing had been on the county's delinquent property rolls for 11 years, and the holding company that had owned it had been dissolved without anyone addressing the tax liability. Whatever the explanation, the 0.4 acres had been on the county's tax auction listing on a Monday, and Renata had read it with her particular set of eyes, and had spent Tuesday morning reading everything else that needed to be read, and had submitted a $7 bid at 11 in the morning. The auction closed at noon. No other bids were submitted. She had won. Carmen came home at 6 to find Renata at the kitchen table, with her professional library spread across the surface, and 3 legal pads filled with notes, and the laptop open to the city's planning portal. Carmen was 41, and worked in hospital administration, and had the practical efficiency of someone who managed complicated situations for a living, and could read a room accurately. She looked at the table. She said what happened. Renata said she had bought something this morning. Carmen said what? Renata said a piece of land in the Callaway district. Carmen said for how much? Renata said $7. Carmen sat down. Renata explained. She was a lawyer by training and by instinct, and the explanation was organized and sequential, and covered the relevant facts in the correct order without editorializing. She told Carmen about the parcel and its position in the Callaway Capital land package, and what that position meant for the $40 million development project that Callaway Capital had been planning for 3 years. Carmen listened without interrupting, which was not her natural state, and indicated the specific quality of her attention. When Renata finished, Carmen was quiet for a moment. Then she said this was either very smart or very something else. Renata said she thought it was very smart, but that it depended on several things being true that she had strong reason to believe were true, and some reason to believe might not be entirely true, which was the nature of legal analysis generally. Carmen said what things? Renata said the zoning status of the parcel, which she had verified from the county records, and which confirmed the parcel was zoned in a way that was compatible with the development Callaway Capital was planning, and that she therefore had the right to develop or to withhold from development. She said the title status, which the county deed would confirm, but which she had verified from the tax records as belonging to the dissolved holding company, with no subsequent transfer. She said the absence of any easement or covenant that would give Callaway Capital or any other party a right over the parcel regardless of ownership, which she had checked through the title history available in the county records and had found nothing that contradicted her position. She said she was going to need to do a full title search to be certain, and that the full title search was going to require a county records fee that she was going to have to manage from the $430. Carmen said how much was the fee? Renata said $40. Carmen said she would cover the $40. Renata said she did not need Carmen to cover it. Carmen said she was covering it. They looked at each other in the way of sisters who had been having versions of this conversation for decades, and who both knew exactly how it was going to resolve. Renata said thank you. Carmen said when do you find out if it worked? Renata said that Callaway Capital did not yet know she had the parcel, because the deed would not be processed and publicly recorded for several weeks, and that she had a window of time in which to do the necessary verification before the situation became known to the other party. She said she needed to use that window carefully. She said she was going to start with the full title search in the morning. The full title search took 3 days and cost $38 in county records fees, and confirmed what she had established from her preliminary research without finding anything that contradicted her position. The parcel was hers. The title was clean. There were no easements, no covenants, no rights of way, and no recorded agreements that gave any other party any claim over the land. The dissolved holding company had owned it without encumbrance for 11 years. And the tax delinquency had been the only outstanding matter attached to it. On the 4th day, she called the city's planning department and asked a question that was not about her parcel specifically, but about the Callaway Capital Development Project generally, the kind of question a member of the public with an interest in local development could ask, and that was answered with the public information available on the planning portal, supplemented by the specific detail that a planning officer provided when the question was asked by someone who asked it in the right way. The planning officer, a young man named Phil, who had the helpful manner of someone new enough to the position to still find inquiries interesting rather than routine, confirmed that the Callaway Capital project had received preliminary planning approval and was in the final stages of the approval process before construction permits could be issued. He confirmed that the approval was contingent on the applicant demonstrating clear ownership of the full development footprint. He confirmed that the final review meeting was scheduled for 6 weeks from the following Monday. She thanked Phil. She put the phone down. She looked at the legal pads on Carmen's kitchen table. 6 weeks. She needed to decide what she was going to do with the $7 of land in the middle of Callaway Capital's $40 million project, and she needed to decide it with the specific rigor that decisions of this kind required, which was the rigor of a land use attorney who understood both the legal position and the practical implications, and the range of possible outcomes, and their relative likelihood. She had 3 options. The first was to do nothing and allow the planning process to proceed to the point where Callaway Capital's inability to demonstrate ownership of the full footprint became the planning department's problem, which would delay or potentially derail the project without Renata taking any active step. This option was passive and potentially powerful, but carried the risk of outcomes she could not fully control. The second was to contact Callaway Capital directly and disclose her ownership and open a negotiation. This option gave her control over the process, but required her to initiate from a position she had not yet fully established and to negotiate with a party who had significantly more resources and experience in commercial negotiation than she did, though her legal knowledge was the specific equalizer in a situation that was fundamentally a legal question. The third was to consult a lawyer, not as her attorney but as a colleague, someone from her professional network who could provide a second set of eyes on the legal position before she moved in either direction. She chose the third option first. She called a woman named Patricia Osei, who had been 2 years ahead of her at law school and who had spent 20 years as a property litigation specialist at a firm in the city, and who answered Renata's call with the warm directness of someone who had always liked her and whose schedule was genuinely full, but who made room for this conversation because the summary Renata gave in the first 30 seconds was the kind of summary that made room for itself. Patricia listened. She asked 3 specific questions, each of which went to the exact point of the legal position in the way of someone whose 20 years of property litigation had given her the specific literacy for this kind of situation. Then she said that Renata's analysis was correct, and that her position was strong, and that there was an additional consideration she may not have fully weighted. She said the additional consideration was the environmental assessment. Renata said, "What about it?" Patricia said she had been involved in a case 2 years ago involving a Callaway Capital development in the Western District that had been delayed 18 months by an environmental assessment challenge. She said Callaway Capital had a pattern of environmental assessments that were thorough in the areas relevant to their development plan and less thorough in the areas that were not. She said that a 0.4-acre strip running through the center of a 3-acre site in an area with the industrial history of the Callaway district was the kind of parcel whose environmental history warranted specific scrutiny. She said that if there was anything in the environmental history of that strip that had not been assessed in Callaway Capital's environmental documentation, it would be relevant to the planning approval in a way that was separate from and additional to the ownership question. Renata said she would look into it. She spent 2 days in the county environmental records, which were public and which she navigated with the professional fluency she brought to all public record systems. She found what she had not looked for initially because Patricia had pointed her toward a possibility she had not considered. The narrow strip of land in the middle of the Callaway Capital footprint had been, in the 1940s and 1950s, the site of a chemical processing operation that had been documented in environmental assessments conducted in the 1990s as part of a citywide industrial legacy survey. The assessment had been conducted, and the strip had been flagged as requiring remediation monitoring. The monitoring had been assigned to the holding company that had subsequently dissolved. The dissolved holding company had not completed the monitoring requirement before its dissolution. The requirement had not been transferred to any subsequent responsible party because the holding company had dissolved without proper wind-down of its obligations. The environmental monitoring requirement was therefore unresolved. The Callaway Capital environmental assessment for the development project had not addressed this historical requirement because the requirement was attached to a separate parcel that Callaway Capital had not owned and had apparently not assessed in detail, the assumption being that the parcel was either not part of their footprint or that its status was not their concern. The parcel was part of their footprint, and its status, she had just established, was her concern and theirs. She called Patricia. Patricia listened to the environmental finding. She said that this changed the character of the situation considerably. She said that in her experience, a situation with both a title position and an environmental compliance issue had a different resolution landscape than a situation with only a title position. She said she would like to discuss how Renata intended to proceed. They talked for an hour. The letter went to Callaway Capital's legal department on a Monday morning, 6 weeks before the planning review meeting. Renata wrote it herself, which was the correct approach because it was a legal letter, and she was a lawyer, and the letter needed to be written by someone who understood every word in it, and the specific implications of those words and the context it was being sent into. The letter was 4 pages. It disclosed her ownership of the parcel. It outlined the title history and the clean title she held. It described the environmental monitoring requirement and its unresolved status, and the implications of that status for the planning approval process. It explained what she was prepared to do and what she was not prepared to do, and the conditions under which she would consider what she was prepared to do. She was not asking for $40 million. That was not the position, and she had never intended it to be the position. Because an unreasonable position was not a position. It was a declaration of war, and declarations of war against parties with significantly more resources were not strategic. She was asking for a figure that reflected the genuine value of the parcel to the development project, the cost and timeline of the environmental compliance resolution that her ownership of the parcel made possible, in ways it was not possible without her cooperation, and the professional services she was uniquely positioned to provide in navigating the land use and environmental compliance process that the development now faced. She was, in the language of the letter, offering to be the solution to the problem rather than simply the source of it. The letter was sent by registered post and by email to the address listed on Callaway Capital's publicly filed planning documents. She received a response in 4 days. The response was from a lawyer named Gregory Holt, who identified himself as Callaway Capital's general counsel, and who wrote with the composed neutrality of a professional who had been given a problem and was assessing its dimensions before responding to it. He said he would like to arrange a meeting. She said she would be available the following Tuesday. The meeting was in Callaway Capital's offices, in a building in the financial district that had the specific quality of spaces designed to communicate the scale of the organization they housed. Renata arrived in the blazer she had worn to the best interviews of the past 14 months, and with her professional library's relevant sections tabbed and organized in a folder that she set on the conference table in front of her. Gregory Holt was 62 and had the experienced composure of a lawyer who had been in many rooms like this one, and who had assessed Renata's letter with the professional precision its precision deserved. Beside him was a man named Robert Callaway, who was the company's founder and who had the specific quality of people who had built significant things from the ground up and carried the confidence of that construction in the way they occupied a room. Robert Callaway looked at her across the conference table and said he wanted to understand how she had found the parcel. She said she had been reading tax auction listings. He said why. She said, because she was a land use attorney who understood what certain listings meant, and she had been looking for one that meant what this one meant. He looked at her for a moment. He said she had found it. She said she had found it. He said he wished his team had found it first. She said she imagined he did. He said what did she want? She set her folder on the table and opened it to the first section. She said she wanted to tell him what she was prepared to offer before they discussed figures, because she believed the value of what she was prepared to offer was the context in which the figures needed to be understood. She talked for 20 minutes. She talked about the environmental compliance requirement and the pathway to resolution she had identified, and the timeline that resolution would require, and the specific expertise that navigating that pathway needed. She talked about the title position and the deed transfer process, and what her cooperation in that process would mean for the planning approval timeline. She talked about what the alternative looked like, not as a threat, but as an analysis, the honest description of what the planning review meeting in 6 weeks would produce if the ownership and environmental issues were unresolved. She said that the alternative was a project delay she estimated at a minimum of 18 months, and potentially longer, depending on how the environmental compliance process developed. She said she was not interested in delaying a $40 million project. She said she was interested in resolving the situation in a way that worked for both parties, and that got the development built and got her established in the consulting and compliance work that she had been unable to find a door into through 14 months of conventional application. Robert Callaway looked at Gregory Holt. Gregory Holt looked at his notes. Robert Callaway looked back at Renata. He said, what specific arrangement did she have in mind? She told him. The negotiation took 3 meetings and 11 days. She retained Patricia as her legal counsel for the negotiation, which cost her the last of the $430 and an agreement to pay the remainder of Patricia's fee from the settlement proceeds, and which was the correct decision because having a lawyer in a negotiation with a party who had a lawyer was not a luxury, but a requirement. The arrangement that was finalized on the 11th day included a payment for the parcel that reflected its strategic value to the development rather than its assessed value as a piece of vacant land, a consulting contract for the environmental compliance work that would occupy the next 12 months, and a first right of refusal on the land use consulting work for Callaway Capital's 3 subsequent planned projects in the Callaway district. She signed it at the conference table in the building in the financial district on a Wednesday afternoon, with Patricia beside her and Gregory Holt across the table. Robert Callaway, who was not a man who attended signings as a general practice, was there. He said to her after the signing, in the direct way of someone who respected directness, that he wanted to know what she had paid for the parcel. She said $7. He looked at her. She said $6.87 had been the outstanding liability. The county required whole dollar bids. He said she had bid $7. She said she had bid $7. He said, and nobody else bid. She said nobody else had read the listing the way she had read it. He was quiet for a moment. Then he said he was going to make sure his acquisitions team started reading listings differently. She said that was a reasonable response to the situation. She picked up her copy of the signed agreement and put it in the folder beside the tax auction confirmation that she had printed on the morning of the bid and kept because she had learned over 16 years that documentation was the foundation of everything that came after it. She walked out of the building into the afternoon. Carmen was waiting at the coffee shop on the corner because Renata had told her the signing was today, and Carmen had decided that being nearby was appropriate, regardless of whether she had been asked to be there. Renata sat down across from her. Carmen said, well. Renata said it was done. Carmen said, how done? Renata said, substantially done. She said the figure. Carmen looked at her for a long moment. Then she said, that covered considerably more than the $40 she had contributed to the title search. Renata said it covered considerably more than that. She picked up the coffee Carmen had ordered for her and drank it. It was not cold. She thought about a Tuesday morning in September, and a laptop that made a thinking sound, and a $7 bid on a strip of land that most people had read past because they were not reading with the right eyes. She had been reading with the right eyes for 16 years. She had finally found the right listing. She opened the folder on the coffee shop table and looked at the signed agreement one more time. Then she closed it and looked at her sister. She said she needed to find an office. Carmen said she knew someone who had a sublet available. Renata said of course she did. Carmen said it was what sisters were for. Renata said she supposed it was. She finished the coffee. She had work to do.